You're going to enter a plea of guilty to 1 count of breaking and entering. It's 5th-degree felony, punishable by up to 12 months in prison and a $2,500 fine. If you violate the terms of your supervision, and I do have to send you to prison, the maximum also includes an optional period of post-release control of years. There's also a criminal damaging, which is a 2nd-degree misdemeanor, punishable by up to 90 days in jail. Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to counts 1 and 3, that on or about April 10th of 2025 in Deerfield Township, Warren County, Ohio, defendant David Hood trespassed into a business to commit a theft offense. Specifically, he was a former employee of Landon Motors. He was going into the building to retrieve tools. He was positively identified by surveillance video. He gained access to the building by entering through a side window, damaged a table in the process, opened a garage door to the vehicle repair building, loaded tools and other items into his vehicle. He had been terminated by the company several weeks prior. Table belonging to the business was damaged. Tools were taken in the process of this.
Any on those facts, Ms. Hinkle?
Just that my client states that the only tools that were taken were his own, but we would stipulate to the rest of the facts.
See everybody back here in about 8 weeks. Ms. Hinkle, go ahead and set this for a half-hour sentencing, because we're going to have some issues regarding restitution and regarding the motion to modify the bail. So I don't care if you're going to come up positive for marijuana. That doesn't matter to me. So I'm not going to approve it, but I'm also not going to violate you if you test positive for weed. Okay? All right, that's all.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Hood, 25 CR 43011. Present before the court is Mr. Hood, represented by Mr. Ocella. We have Mr. Harris in the prosecutor's office and Officer Fisher from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor. I do have some information. I was in contact with the victim advocate. The victims in this matter, I know we were here the last time. They were not present. I did text message victim advocate, who did call and got a hold of the victim in this matter. He thought it was for April 11th, and he cannot be here anytime soon, I guess today. We are requesting one last continuance. I'm really not sure why. There was some disconnect there. I know we'd done this before, and I think even prior to that, the case has been set many different times, and I know Mr. Hood had different counsel at one time who withdrew, so I would ask for one more indulgence of the court one last time.
All right, I'm not going to grant the request to continue the sentencing hearing, so we're going to go forward today. We have 4 days of jail time credit. There is part of the restitution that is uncontested, right?
That is correct.
That is
Your Honor.
correct.
What is the part of the restitution that is uncontested?
There's a broken table valued at $300 and a cleaning chemical solution that was dumped out valued at $542.22 for a grand total of $842.22.
Your Honor, I do have a list, an itemized list of these things. The defense has a copy of that. It came to $5,700 is what the request was. There's an itemized list I have if the court
Okay.
take a look at
All right, we'll mark that as State's Exhibit 1.
Yes.
You may approach.
Thank you.
Judge, I would object to the admission of that document as any part of the court record. There are a number of items on that list. Well, first of all, the origin of it, it's very generic and bland. Doesn't have anything attached to this business, and throws out values without receipts. There's nothing to substantiate the values in that list, and several of the items on that list were my client's personal property.
Okay, which items were Mr. Hood's personal property?
The sockets kit valued at $290. The ratchets kit valued at $189.99. The impact wrench valued at $349.99. The compression tester kit valued at $930. And the oil filter wrench kit valued at $110.99.
Mr. Harris, anything additional from the state?
Your Honor, regarding those, without testimony, I can't further substantiate that. I know this was submitted by the Landon Motors, so they're saying these items were missing. Obviously, they believe that those were their property. And if you recall, the defendant did come in through a window, broke a table coming in. He was caught on surveillance video. I'm not really sure why you would need to do that if this is your own property.
So was the broke side drill taken from the premises?
That's what they're alleging.
Do we
correct?
dispute that the broke side drill was taken?
We're disputing everything that I've not highlighted for the court already.
Okay.
So the individual items and the 2 items that were stipulated to for value are the items that we are, we stipulated the 2, the other ones are personal items. And then the other items we're contesting that my client simply didn't take. And
Okay.
Mr. Harris can put whatever he'd like on the record, but he wasn't there, he wasn't present, and it's total speculation and conjecture. So I would come back to what I stated earlier. I would object to that document coming in as an exhibit to the court record because there's nothing to substantiate any of it.
So I think we're clear, the items on State's Exhibit 1 are the things that the victim says were taken in the case.
Correct. Yeah,
Okay.
yes.
All right. Anything else from the state?
Your Honor, I just add, we go through this at any restitution hearing. The victim will come forward and say what their losses are. They did submit this itemized list with value, and I guess it becomes a question of credibility at this point. So as I said, the manner in which these items were taken affects credibility, I believe, of the defendant, and why he's more believable at this point, I would truly question.
Officer Fisher, anything from probation?
Nothing further, Your Honor.
Mr. Riccello?
This is an issue of credibility. It's meeting the elements, and the state hasn't done that. So aside from what's been stipulated to, I'd ask the court to find no additional restitution is owed. There's no one here to substantiate or corroborate or provide any evidence to support anything that's listed in this item other than my client who's here, and if the court wants, ask him questions about it.
Okay.
So,
Mr. Hood, do you swear or affirm that the testimony you're going to give is going to be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
You've seen Exhibit 1, right?
Yes, Your Honor.
We have the broken table and the cleaning chemicals, which you acknowledge are restitution, right?
Yes, Your Honor. I will acknowledge that I may...
Hold on, just answer my questions, Mr. Hood.
Yes, Your Honor.
So your attorney said that certain items being the sockets kit, the ratchets kit, the compression tester kit, and the wrenches kit, oil filter wrenches kit, those all belong to you.
and the impact wrench, Your Honor, valued at $349.99.
Yes, and the impact wrench, those all belong to you.
Yes, Your Honor.
Right? And you didn't take anything else on this list.
No, Your Honor.
Yes,
Sorry.
no question.
Yes or no, sorry.
Mr. Harris, do you have any questions for Mr. Hood?
Mr. Hood, you were going to finish the answer to that question. What was it?
No, I'm advising my lawyer's advice.
So you're remaining silent.
Any other questions, Mr. Harris?
No, Your Honor.
Mr. Ocello?
Nothing. Your
Okay,
Honor.
all right. So, off the issue of restitution, what do I need to know about sentencing?
We'd ask the court to give Mr. Hood the 4 days of credit. We'd ask him to, ask you to place him on a period of reporting probation, community control, and allow him an opportunity to pay the restitution back to the victim, to items that were stipulated to. As Mr. Hood had just testified to, that he did not take the laundry list of other items that were listed, aside from his personal items, and again, the 2 that were stipulated to. So we would ask the court to consider what's been stated here this morning and allow Mr. Hood to continue moving forward.
Anything you want to tell me, Mr. Hood?
I just look forward to getting this behind me and getting everything straightened out and living my life, keeping straight.
All right, court's going to place you into my community control program. I'm going to do that for a period of 3 years. I'm going to impose upon you the standard rules of community control, delegate to your officer the ability to make special or additional conditions as they see fit. It's going to be a term of your community control that you complete some sort of corrective thinking, something along those lines. Officer Fisher, I don't know if I have strong feelings about what that is. So Officer Rose, this is Officer Rose's case, right? Or is this your-
Correct.
So whatever she and Mr. Hood agree on, I can probably handle. I think that, let's go with it. Let's go with the corrective thinking. And do you take medications for your mental health?
I do not, Your Honor.
Okay.
I do use my medical marijuana, which you did say that you were not approved the medical card, but you were not deeming it for the THC last time I was in court with you.
Well, that's why you were on. That's why you were on pretrial. On pretrial, I don't really care that much. On probation for this offense, I don't really care that much either. You're employed, right?
I'm working part-time right now, yes.
Okay. As long as you can keep a job, then the medical marijuana is okay. If you can't keep a job, then no point in having the medical marijuana if you can't stay employed. I'm going to order that you serve 30 days in the county jail. I'm going to credit you the 4 days that you have already done. I'm not going to impose a fine. I'm going to impose the restitution in the amount of $842.22. We're going to remove him from the monitor today. He wants to schedule the jail through probation, right, Mr. Ocello?
Presumably.
Yeah, can I do that in settings, like I go for a week, I come out for a week, or is it just straight?
I'm not against that, so we'll do.
Okay, because I have a newborn baby at home and I like to spend time with her as much as I can.
We can split it up into three blocks.
Okay.
If you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in the case, which is 12 months in prison, plus an optional period of post-release control of up to 2 years. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript or to pay the cost, they'll all be provided to you without charge. Good luck to you, Mr. Hood.
Thank you.
John,
Judge.
we have a no contact order with.
Oh, yeah, no reason to have any contact with anybody at Land Motors.
No
right?
reason at all.
All right, so not on the business premises, not to have any contact with the people that work there.
Thank you, Your Honor.
All right.